In the heart of Malaysia's thriving business landscape lies a web of intrigue, responsibility, and hidden threats. Behind the polished facades of corporations, one crucial figure plays a pivotal role in safeguarding transparency and compliance. The company secretary.
Join us on an eye-opening journey as we delve into the intricate world of company secretaries in Malaysia. Through compelling case studies and in-depth interviews, we shed light on the challenges they face, the pivotal decisions they make, and the ethical dilemmas that test their mettle. Good morning, Mr. Lee. Thank you for joining us today. How are you?
Good morning, Mr. Danish. I'm doing fine.
So, Mr. Yi, I think you know why we are here today. What it really went down on the case of Yi Tek Fah and Ano versus Wong Nip Lim and Ano. How did it all begin?
Well, my son and I, represented by our law firm, Mr. Yi Tek Fah and Co., sought to transfer share from the registered shareholder, Mr. Lee, to ourselves as a beneficial owner. So, however, despite our efforts, the transfer was not completed in 2018. In 2019, we reiterated our ownership status and instructed the company secretary, Mr. Wong Yip Lim, to reflect our ownership in the company's annual return. Mr. Lee also instructed the company secretary to proceed with the transfer. At that point, there were no indication of any dispute regarding the ownership of the share. So, however, later on, Mr. Lee lodged a police report alleging fraud and instructed the company secretary to proceed with the transfer.
So, this is when you filed a lawsuit, is it?
Yes, this was when my son and I filed a lawsuit against the company secretary, Ms. Wong, claiming breach of contract and negligence in carrying out the transfer.
One of the key issues in this case was the existence of a contract between you, your son, and the company secretary. The court determined that there was no such contract based on the evidence presented. What's your take on this?
Yeah, the fact that an invoice was issued to and paid by our law firm did not establish a contract with the company secretary personally. So even if a contract had existed, the company secretary would not be obligated to proceed with the share in the presence of objection or contrary instructor from the company or the registered owner.
Wasn't there a claim of negligence too?
True, the court recognized the company secretary owed a duty of care to us as the intended beneficial owner of the share. So they were expected to consider our interest when carrying out the transfer process. So, however, the court has concluded that company secretary had not been negligent in stopping the transfer due to ongoing dispute over the ownership of the shares. So the decision to halt that transfer was deemed necessary based on the instruction from the police.
Thank you for clarifying those points. How do you believe this case impacts the obligations of company secretaries under the Companies Act 2016?
This case has established that company secretary can owe a duty of care to third party, including intended transfer of shares. So it emphasizes the importance of company secretary exercising proper skill and care when facilitating share transfer to protect the interests of all parties involved. So it further solidified the notion of company secretary have obligation beyond just the company itself, extending their duty of care to other parties within the corporate process. Furthermore, we can align this decision with practicing the guideline which stated that the company secretary should act honestly and with reasonable diligence. So it implies that company secretary owe a duty of care to directors and also shareholders in various situations. So Therefore, it is very crucial for a company secretary to exercise reasonable care when fulfilling their responsibilities.
The High Court's ruling in Yi Tek Fa has clarified that company secretaries have a duty of care towards third parties, specifically intended transferees of shares. This means that company secretaries must act with skill and care when facilitating transfers. The court's decision establishes that a company secretary's duty of care extends beyond the company itself and includes other parties involved in the corporate processes.
Greetings, Ms. Nur Hayati. How are you? And please do introduce yourself to the viewer.
Good evening to the people watching. I'm Nur Hayati. I'm one of the shareholders of Eka Noodles Berhad.
So, Ms. Nur Hayati, according to my knowledge, you issued Eka Noodle Berhad a notice of general meeting on 31st May 2021, asking them to adopt a number of resolutions. What happened then?
Yeah, I gave the corporation a notice of the general meeting on May 21st, 2021. And I own more than 15.66% of the outstanding shares of Eka Noodles as a shareholder of the business. The resolutions in the notice was related to the resignation of the two company secretaries, the dismissal of the directors, and also the appointment of new directors and new company secretary. The notice was published in accordance with Section 311 of the Company Act 2016. But however, Eka Noodles filed a lawsuit against me 2 days after I gave the request notice, effectively asking for declarations that the request notice and the general meeting holdings on June 29 are invalid, void, and also unenforceable.
So, what were the issues raised by the plaintiff?
There are two issues were raised, which whether a single member holding 10% of a company shareholding can requisition a meeting, whether the directors must call a meeting after receiving a requisition from the shareholders, and also whether a proposed director's written consent and declaration of disqualification must be delivered along with a notice of requisition and proposed resolution for appointment.
After all that, how did the court rule?
Eka Noodles' argument was dismissed by the court. The court determined that the directors were required by law to hold the general meeting. This is despite the fact that I was attempting to remove all of them. Instead, the directors declined to call the general meeting, relying on their own wrongdoing to prevent my entitlement as a shareholder to reconstitute the company's board of directors. And also, the court ruled that as long as a shareholder has the numerical power to convene a meeting, the shareholders is entitled to do so. And yes, the decision was favorable to me.
Coming back to the company secretary role in this, how does this affect the company secretary's duty under the Companies Act 2016?
It has no direct influence on a company secretary's general duty or the procedures for an annual general meeting under the Companies Act. It does, however, offer some insight into the interpretation of key status and processes pertaining to general meetings. Concerning the company secretary, it has been clearly stated that the board of directors has the authority to remove a company secretary. In terms of the AGM, the case provided understanding on the interpretation of regulations in the Companies Act relating to the calling of a general meeting upon member request. It was clarified that the term members refers to both singular and plural forms and so might refer to a single member firm.
Ms. Nur Hayati won this case, and it was determined that the board directors have the authority to remove the company secretary from a company.
Being a company secretary is more than just managing paperwork and ensuring legal compliance. We are the guardians of corporate governance, entrusted with upholding the values of transparency, accountability, and integrity.